Hello, my name is Elie, and I am proud to volunteer with Lyric, Learn Your Rights in the Community. Lyric stands for the education and empowerment of young people. We teach young people and their families how to safely exercise their constitutional rights when interacting with the police. In this video, I will teach you about the principles of the Fourth Amendment and what rights youth have when contacted by the police. As a heads up, I'm not going to cite specific cases most of the time, but should you want to research the law presented, we will flash the case names and citations across the screen as I discuss them. Hopefully, it goes without saying that nothing we present in this video should be construed as legal advice. This video should serve as an educational piece, especially for folks who are training to become Lyric volunteers. We're thrilled to have you. This short video aims to teach lawyers and law students about the law that creates the foundation of the Lyric curriculum. The curriculum teaches this material in a youth-friendly way, and you will learn how to break these concepts down to the youth in video 3, How to Teach a Lyric Presentation. But before we jump into case law, I want to start by talking about what the Fourth Amendment at its core means. Here is the language of the Fourth Amendment. The Fourth Amendment is meant to protect us all from unreasonable searches and seizures. In other words, it is our constitutional protection against police violating our personal boundaries and our privacy without the proper legal justification. This is the piece of the Constitution that is meant to keep our belongings personal, our homes secure from governmental intrusion, and our bodies safe from police. This presentation on the Fourth Amendment is divided into 4 categories, describing how people might interact with police. 1, as pedestrians. 2, in cars. 3, in one's home. And 4, when at school. Now let's get to it. Section 1, pedestrian searches and seizures. The core of this section of our curriculum is meant to address 2 questions. When can a police officer legally detain a juvenile on the street, and when and what can they search? As an overall matter, the same general rules apply to juveniles as adults for pedestrian seizures. Now, there are 3 types of pedestrian contacts: consensual contact searches, temporary detention, and seizure akin to a formal arrest. Consensual contacts do not implicate the Fourth Amendment, as they are not considered seizures. According to Florida v. Bostwick, seizure does not occur simply because an officer approaches and asks questions. A consensual encounter between a police officer and a citizen can transform into a seizure or detention, quote, if in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave, unquote. Be sure to research relevant case law to understand what circumstances may transform a consensual encounter into a seizure or a detention. Onward to temporary detentions. The bedrock principle here comes from Terry v. Ohio. A police officer must have reasonable suspicion that a crime has been, is being, or is about to be committed to justify a temporary detention. There is endless debate about what can substantiate reasonable suspicion. But for this video's purposes, reasonable suspicion means more than an inchoate and unparticularized suspicion or hunch. At the end of the day, the police, quote, must be able to point to specific and articulable facts, which taken together with rational inferences from those facts reasonably warrant the intrusion, unquote. Keep in mind that, quote, only when the officer by means of physical force or show of authority has in some way restrained the liberty of a citizen may we conclude that a seizure has occurred, unquote. Let's make this a little trickier. A limited search is permissible during a temporary detention. You may have heard about these limited searches before. The policies that allow for this sort of limited search are commonly referred to as stop and frisk. If an officer has a reasonable suspicion that someone is armed and dangerous, the officer may conduct a pat-down for weapons. But you might be saying here, Elie, I still don't totally get how to define reasonable suspicion. Can you help? To which I say, yes I can. In addition to being more than an inchoate and unparticularized suspicion or hunch, reasonable suspicion for a stop and frisk requires an objectively reasonable belief that the suspect is dangerous and may be able to gain control of a weapon. If during a justified pat-down, an officer feels an object they immediately identify as evidence of criminality, it may be seized. This could be anything, from feeling something resembling a pipe to feeling something resembling a gun. Questions? I don't see any, so we will move on to seizure akin to a formal arrest. Police must have probable cause to believe a person has committed or is committing a crime in order to make a seizure akin to formal arrest. A seizure can happen even if a person is not in formal custody per the Fifth Amendment. For more on the Fifth Amendment, watch the Lyric Volunteer training video on the Fifth Amendment. Usually, this type of seizure is typically in a public place. Because it happens in a public place, the potential for police to use coercive tactics to compel a confession is diminished. Supposedly. Here's an example. An officer told someone to sit down and wait for witnesses to arrive for a show-up identification. Because of the public location, the presence of multiple witnesses, and because of the person who was told to sit had calm demeanor, the court found the person sitting down had not been placed in formal custody at this point. This was considered a show-up identification, and a valid seizure short of formal custody per the Fifth Amendment. If you have been paying attention, a few holes have been punched into our Fourth Amendment rights. Almost every time we present to young folk, we get a question about cell phones. If a police officer arrests you and searches you or your stuff, the officer is still not allowed to search your cell phone unless he has a warrant signed by a judge. Let's shift our focus to our Fourth Amendment rights when we are in cars. Here, our core question is, when can a police officer stop a vehicle and search the interior? First off, a valid warrant allows for an officer search. We won't get into the scope of warranted searches here. For this training's purpose, we are focusing on warrantless searches. The general rule for all warrantless searches comes from Katz v. United States. Quote, "Searches conducted outside the judicial process without prior approval by judge or magistrate are per se unreasonable under the Fourth Amendment," unquote. In other words, searches without a warrant, by default, are unconstitutional. That said, the exceptions far outweigh the rule here. So when police stop a vehicle, drivers and passengers are considered seized. This means passengers have the same constitutional standing to object as drivers. One more thing about vehicle seizures. The seizure can become illegal if a police officer completes the original purpose for the stop and then continues to detain the vehicle without any additional justification. A prolonged detention of the vehicle, regardless of the additional time the vehicle is detained, amounts to an unconstitutional seizure, which would require suppression of any evidence found after the original purpose of the stop has been completed. Officers can perform a warrantless search of the vehicle under the following circumstances: limited search incident to arrest, an inventory search, or under the automobile exception. The first exception, limited search incident to arrest. A vehicle may be searched incident to arrest, quote, only if the arrestee is within reaching distance of the passenger compartment at the time of the search, or it is reasonable to believe the vehicle contains evidence of the offense of arrest, unquote. In other words, can the driver or passenger reach a weapon or evidence of a crime committed or to be committed? Or does the car have evidence of a crime justifying the vehicle stop? Next exception, inventory searches. Quote, an officer who has lawfully taken a vehicle into custody may conduct an inventory search of the contents of that vehicle, unquote. The theory here is that the purpose of the search is to, quote, protect an owner's property while it is in the custody to ensure against claims of lost, stolen, or vandalized property, and to guard the police from danger, unquote. Even though an inventory search exception seems widely abusable, the search, quote, may not be used as a ruse for general rummaging by the police, unquote, in order to find incriminating evidence. Next, The automobile exception. Officers can perform a warrantless search on a seized vehicle when there is probable cause to believe the vehicle contains illegal items. This is played out, for example, in cases where the officer had probable cause to believe a car was filled with illegal drugs. That's it. Those are the exceptions. Limited in number, but expansive in permission granted to police and detrimental to the once bold security of the Fourth Amendment. Obviously, police use a variety of common pretextual justifications to seize cars before relying on one of these exceptions to perform a valid warrantless search. When can a passenger object to the search? When that passenger has either a property or possessory interest in the automobile searched or in the property seized. And that is a 50,000-foot view of the Fourth Amendment rights you don't have when in a vehicle. Now let's talk about searches of homes. When can a police officer come inside a house? And what can be searched when they do enter? The Fourth Amendment protections are strongest in the home. Generally, any search of a home or dwelling requires a warrant. There are only two exceptions: under an emergency or by consent. Police may search a residence without a warrant where circumstances make getting a warrant impracticable and risky, or probable cause exists to believe the residence contains evidence of a crime or the suspect. Heads up, hot pursuit typically qualifies as an emergency. Police may search a home when the resident consents to the search. Consent must be voluntary, not the product of threats, intimidation, or harassment. How do we know if it was voluntary? Great question. The court will ask, would a reasonable person in the subject's position have felt free to decline the officer's request? What if multiple people live in the house and one person doesn't consent while the other does? Consent may come from someone who shares authority over the area. Typically, a person must be an overnight guest to have standing to consent to a home search. What about home searches of people under 18 years old? What if that young person does not consent to a search of their room, but their parent does consent? What if the young person pays rent? What if the young person has a locked container within their room and their parent does not have a key to it? There are truly countless permutations and variations to explore the breadth and scope of the Fourth Amendment's protections. There is rich case law on the matter, and we encourage you to research case law to explore each of these hypothetical situations, and others. When can a police officer search a student's locker or backpack? When can a principal search a student's locker or backpack? The reality is this: most school-based searches are conducted by school staff who are not police. The Fourth Amendment applies in schools, but the standard for a search at a school is even lower than reasonable suspicion. In other words, students have fewer protections against unwarranted searches when the students are in school hallways. There must be reasonable grounds for a school official to suspect that the search will turn up evidence of a violation of the law or of school rules. The scope of the search must be reasonable. So, there you go. Those are the broad strokes of how the Fourth Amendment applies to young folks as pedestrians, in vehicles, at home, and at school. Obviously, there is a lot of nuance to each individual factual circumstance. That is both the beauty and the frustration of the Fourth Amendment jurisprudence. That said, this video covered the broad strokes in areas that often come up in Lyric presentations. We provided case citations in the graphics to help you all use this video as a jumping off point for further research, or to help you answer questions that may come up with Lyric students. Thank you for watching this video on the Fourth Amendment principles informing how Lyric teaches our students. Please take some time to watch the other videos covering the Fifth and Sixth Amendments, and also our video that breaks down how to teach the Lyric curriculum to youth. Remember, give them 5. Am I free to leave? I do not consent to you searching me or my stuff. I want my parent or guardian. I want my lawyer. I would like to remain silent. Peace.